안녕하세요. 저 스칼리 변호사입니다. 오랜만입니다. 오늘 이 세미나에 관해서 제가 간단히 오늘 소개해드릴 텐데, 저희는 루이스 브리즈보이 비즈건 앤 스미스 러펌에서 활동하고 있고요. 오늘 이 세미나에 관해서는 저희가 몇 가지 토픽을 커버할 텐데, 하나는 이제 Private Attorney General Act라고 해갖고 약자가 파가입니다. 그래서 많은 분들이 파가에 대해서 이제 질문이 하신 분들이 있는데, 오늘 이 파가 이 스태츄트이 뭔지, 파가가 어떻게 웨이저나 클래스 액션이라는 비슷한 집단 소송하고 어떻게 차이점이 있는지에 관해서 오늘 말씀드릴 거고요. 저희 로펌에 계신 윌리엄 모셔 파트너님이 나오셔갖고 여기에 대해서 말씀해 주실 겁니다. 그리고 두 번째 토픽은 sexual harassment에 관해서 저희가 말씀드릴 거고요. 이 토픽은 저희 변호사 셀린 심 변호사님이 해주실 겁니다. 그리고 저희하고 같이 프레젠테이션 하실 분 또 한 분 계신데요. 이분은 이제 한국에 변호사 활동하신 분인데, 변호사님이고요. 한국에 있는 윤앤양 화우 로펌에서 오셨습니다. 시간이 나면은 나중에 이제 Q&A 세션을 할 건데, 하여튼 시간이 있으면 Q&A 세션을 하고, 아니면 질문이 있으신 분은 이 웨비나가 끝난 이후에 질문을 보내주시면 저희가 정성껏 답변을 해드리겠습니다. 감사합니다. Bill, you're up.
Perfect. Well, thank you for that introduction, Scott. Good morning, everybody. It's a pleasure to have all of you here with us today. My name is William Mosier. I'm the partner at Lewis Brisbois here, and I'm the chair of our Wage and Hour Class Action Practice Group. And for the past 20 years, it's been my job to give employers like yourselves advice on class action and PAGA issues, as well as defend them in class action and PAGA lawsuits. And I'm here today to give you some very important information about PAGA that it's really essential for you to know if you plan on doing business in California. Now, obviously, PAGA is a very, very complicated subject, so we're going to kind of give you some of the basics today. But again, these are very, very important things for you to remember. And then if you have questions, you can feel free to submit them in the chat, or we'll give you contact information at the end that you can use to reach out, and we'd be happy to answer them for you. So first of all, let's start off with something that's very important for you guys to know, which is before we even start talking about PAGA, we need to talk about the different types of claims that somebody can assert in a lawsuit. And the two main types of claims that you need to be familiar with are individual claims and representative claims. Okay? They're two different types of claims. Individual claims are what we think of normally when we think of a lawsuit. Individual claims are claims that an individual has filed for violations of that individual's rights. So if I were to file a lawsuit for something that happened to me, that would be an individual claim. In contrast, there are also what we call representative claims, right? That's where an individual comes in and files a claim for violations of other people's rights, right? A large group of people, not their own rights. And that is a very important distinction to understand, right? We're used to thinking of lawsuits as being one individual versus a company, or one individual versus another individual. But there are also these representative claims where it's not even really about the individual, it's about the group that they're trying to represent. Additionally, when we're talking about representative claims, it's important for you to know that there are multiple different types of representative claims that can be asserted. It's not just one category. So some examples of representative claims where somebody comes in and sues on behalf of other people. There are claims called class action claims. There are collective action claims. There are PAGA claims. And there are mass tort claims, right? So these are four different types of representative claims where somebody's suing on behalf of others, but in a different way, right? These are separate and distinct types of claims, even though they're all what we call representative claims. Now, why is it important for you to know that? Well, it's important for these reasons. Number one, if you have a lawsuit involving individual claims are governed by different rules and different procedures than representative claims. They're handled in a completely different way. Also, each type of representative claim, including the four that I just mentioned, is governed by different rules and procedures than every other type of representative claim. So a class action claim is very different than a PAGA claim. Even though they're both representative claims, they're handled completely differently. So it's important that you know the difference so that you don't mix them up, because knowing what types of claims you have is going to affect how you respond to them. Now, critically, you can assert multiple different types of claims, even in a single action. So in one lawsuit, you could have individual claims, you could have class action claims, and you could have PAGA claims. And even though those are all part of one lawsuit, each one is going to be handled according to different rules. And so you will need to make decisions about how do I respond to the individual claims, and then another decision, how do I respond to the class action claims, and then how do I respond to the PAGA claims, right? And there are different rules that apply, and you will take different approaches in trying to defend them. So before we talk about PAGA, which we're going to get into here next, it's very important that as we go forward, you keep in mind these different types of claims: individual claims, representative claims, and then the different types of representative claims. So today, obviously we don't have time to talk about all of those different subjects, but the main focus of today is to talk about one of those types of representative claims, which are PAGA claims. Now, what does PAGA stand for? P-A-G-A. It stands for the Private Attorneys General Act of 2004, right? It's a specific law that is out there in California. And so when we talk about PAGA claims, what we're referring to is somebody has sued saying that an employer has violated this specific statute, PAGA, the Private Attorneys General Act. Now, something that's important for you to remember about PAGA is that this is a very specific statute, right? It's a law that was written for a specific purpose. And that purpose is to make it easy for employers to sue, employees to sue their employers for labor code violations, right? That's why it was written. And it's sometimes called the sue your boss law, because basically what had happened before then is the California legislature thought that it was too easy for employers to defend against employee lawsuits. And so they wrote a special law to make it very easy for employees to sue and very hard for employers to defend against. That is the purpose of this statute. So when we're talking about this particular statute, when we talk about PAGA, that is what we're referring to, is the language that is contained in this particular law. And what that law says is that aggrieved employees are allowed to assert claims against their employers on behalf of the state of California for any kind of labor code violation that those employers may have committed towards either the employee who filed it, the individual, or other aggrieved employees. Okay. Now, what does that mean? I want to make sure you understand. That's a long sentence. I want to make sure you understand the parts of that because this is very important. Well, who is an aggrieved employee? Who can sue under PAGA? Well, an aggrieved employee is any individual who was employed by the alleged violator, the person who violated the law, supposedly, and against whom one or more violations was committed. So it has to be somebody who you employed and against whom a violation was committed. Now, what does it mean to say they can sue their employer on behalf of the state of California? Well, this is very tricky and very unique to this law. What it means is that even though it is an employee who is suing and putting their name on the lawsuit, they do not own the claims. The claims are actually owned by the state of California, not the person that is filing them, right? These are claims that originally the state of California would have brought against an employer directly. But then the legislature passed PAGA and they said, we are going to give private employees all of the power of the state of California and allow them to basically file claims against their employer as if they were the state, right? That's a very different thing than if they're asserting claims that they own. And we will get into why that is the case shortly. But that's very important to remember. They don't actually own the claims. They are just filing the claims. And then finally, PAGA says they can sue on behalf of themselves or others. Right? We talked about this, individual claims versus representative claims. And so when someone files PAGA claims, they could do so individually, for things that have happened to them. They could do so on a representative basis, meaning for violations that happen towards others, or both. And again, it differs from lawsuit to lawsuit. Some have one category of claims, some have both. So that's an important thing to remember about PAGA that does not apply to some other types of claims. So when we talk about PAGA, we've just talked about kind of who can sue, but what is the scope of the action? What does it cover when somebody asserts PAGA claims? What does it mean to file PAGA claims? Well, in a PAGA action, you have an employee who claims that a specific employer committed specific types of labor code violations towards specific employees during a specific time period. So in every PAGA action, you have to look at it and figure out who is the employee, who is the employer, what types of violations are being claimed, and against who are they being claimed? Because again, they can be asserted on behalf of a group. So who is that group? And over what time period did these violations take place? And it is different potentially in every single action. So in every PAGA action, you will have to answer all of these questions to know what you are dealing with. Now, how do you know this? How do you start to get an idea of what the answer to these questions are? Well, you will get a notice called the PAGA notice. Because under the law, before an employee can file PAGA claims in court, they have to provide the state of California with a written description of the claims they intend to assert, right? The claims are owned by the state, so they have to tell the state, hey, I'm going to exercise my right to assert these claims, against this particular employer. And they have to do that 65 days before they actually file those claims. So you will get a notice 65 days before a lawsuit is filed telling you the answers to these questions. So you will have an idea of what is being claimed by the employee. After that 65 days goes by, they will then file the lawsuit, right? What is called a complaint in court. And just like the PAGA notice, the PAGA complaint will describe the employer that's being sued, or multiple employers sometimes, what violations they're claiming. Sometimes they don't describe it in a lot of detail, but they will say, is this for failure to pay minimum wages, failure to provide meal breaks? There will be a list that they will mention. It will tell you what the time period is, and I will go over how that's calculated in just a second. And they will tell you which employees it covers, right? Is it all non-exempt employees? Is it only employees that work in a specific position? Is it only employees that worked at a specific office or in a specific state? Right? That will all be in the notice, and that will all be in the complaint. And so it's very important that you review both of those so that you know exactly what is being claimed and what is not being claimed. Now, when we talk about the time period that the lawsuit covers, this is very tricky. It actually covers a time period called the PAGA period, starting before the complaint or the notice was even filed, meaning the employee can go back in time and sue for things that happened in the past, as well as for violations that continue on into the future. You have a range. And so what is the start date of the claims? What we call the PAGA period start date generally starts 1 year before the date of the PAGA notice. So whatever the date on that notice is, they get to go back in time 1 year, and that is where the claims start, right? And then continue going forward. Well, where do the claims stop? Where does the time period stop? It stops on what we call the PAGA period end date, which is whatever date the action either settles or a judgment is issued, meaning the date of trial. So when a PAGA complaint is filed, you don't know what the end date is. It continues to grow and grow and grow and grow until the action eventually ends. So the total PAGA period could be 2 total years. It could be 6 total years, depending on how long it takes to conclude the action.
William, can I jump in here and explain something in
please.
Korean? Okay, thank you. 안녕하세요. 아까 소개받은 변호사 송찬미입니다. 지난 세미나에서도 한번 인사를 드렸었는데요. 오늘도 윌리엄 변호사님을 도와서 좀 중요하거나 또는 좀 100% 완전하게 이해하실 필요가 있는 부분에 대해서 한국어로 조금 풀어서 설명해 드리는 역할을 담당할 예정입니다. 우선적으로 개인 소송과 대표 소송의 차이에 대해서 설명드렸습니다. 대표 소송에는 잘 아시는 일반 집단 소송, 클래스 액션이 포함되어 있고 오늘 설명드리는 파가 클레임이 포함되어 있는데요. 이 파가 클레임은 개인 소송일 수도 있고 대표 소송일 수도 있습니다. 아시다시피 근래 한국계 기업에서도 이 파가 클레임이 굉장히 많이 문제되고 있습니다. 이 파가 클레임의 근거가 되는 법률은 Sue Your Boss라는 이제 무시무시한 별칭이 붙어 있기도 하고요. 이제 윌리엄 변호사님이 설명해 주신 것 같이 간단히 말하면 파가 클레임은 한 명의 근로자가 본인 또는 여러 명을 대표해서 고용주, 회사가 노동법을 위반했다고 주장하는 소송입니다. 본인만 대표해서 소송하면 개인 소송이 되는 거고 본인을 비롯하여 여러 명을 대표해서 함께 소송을 하면 대표 소송이 되는 거죠. 이 구분을 왜 하냐면 나중에 중재합의 설명드릴 때 아셔야 되는 필요한 내용입니다. 대표 소송의 경우 단순하게만 보면은 일반 클래스 액션이랑 유사한 면이 있는데요. 어떤 차이가 있는지도 지금 차차 설명해 드리겠습니다. 첫 번째 포인트는 파가 클레임은 소송 명의가 캘리포니아 주라는 점입니다. 근로자가 주를 대신해서 소송을 제기하는 거죠. 따라서 소송 제기하기 전에 방금 설명드린 그 고유한 절차로 먼저 근로자가 캘리포니아의 노동 관련 정부기관인 Labor and Workforce Development Agency, 이 에이전시에 파가 노티스를 보내는 절차가 있습니다. 실제 소송은 이 노티스를 보내고 65일간의 시정기간이 주어진 뒤에 제기되는 그런 시스템입니다. Okay, William, please continue.
Perfect. Thank you, Chanmi. So we've talked about the basics of what a PAGA complaint is, what claims it covers, and what time period it covers. Okay. Now we've also talked about how PAGA lawsuits, again, can be asserted on a group basis. PAGA claims can be asserted on behalf of a large group. So what kind of damages can a plaintiff try to get from an employer in a PAGA lawsuit? Well, in most cases, somebody that files a PAGA lawsuit can recover penalties, if they win, of up to $100 per employee per pay period, meaning that the more employees that they are representing and the more pay periods that are at issue, the longer the PAGA period is, the more in damages they get. So every pay period that goes by, right, you have 50 employees working. right? That's 50 additional pay periods, one for each of those employees. And that's an additional $100 per pay period in damages that the plaintiff can try to recover. So you can see how it will go up very quickly the longer the lawsuit goes on. The shorter the lawsuit goes on, right, the less damages the plaintiff can try to recover. So that's very important to remember. Additionally, and this does not happen all the time, but they can request this, the plaintiff can ask the court to stack the penalties, meaning that instead of one penalty per pay period per employee, they can recover multiple penalties. So, as an example, if you have one employee and the employee did not get a meal break during a pay period and did not get a rest break during that same pay period, the plaintiff could ask for $200 for that employee, one for each type of penalty. That can obviously raise the damages significantly. If there are 6 or 7 types of penalties that occur towards one person in a pay period, right, then the plaintiff is asking for $600, $700 or more dollars per employee per pay period. So that is something they can ask for too. And finally, and this is one of the most important things that I'm going to tell you today. So it's important that you understand this. In a PAGA action, if a plaintiff wins by showing even one violation towards one employee during the entire PAGA period, they automatically are entitled to recover all of their attorney's fees from their employer. So if the plaintiff is trying to represent 500 employees over 5 years, and all they can prove is that on one day, one employee did not get a full meal period, right? Yes, they only get $100 in PAGA penalties for that one violation, but they get all of their attorney's fees through trial, which could be $500,000 or more, right? This is a special feature of PAGA. This is one of the things that makes it so dangerous.
파가 소송에서 근로자가 승소를 하면 고용주에 대해서는 민사 페널티가 부과가 됩니다. 이것도 일반 클래스 액션과 크게 구별되는 점인데요. 기본적인 원칙은 한 명의 근로자당 하나의 페이 피어리드 동안 발생한 회사의 하나의 법률 위반에 대해 받을 수 있는 금액이 $100라는 겁니다. 그리고 후속 법률 위반이 있는 경우 금액이 달라질 수 있고요. 여기서 말하는 페이 피어리드는 임금 지급 주기를 의미합니다. 기본적으로는 2주 바이위클리가 많이 쓰이죠. 그리고 페널티 계산이 페이 피어리드를 기준으로 계속해서 쌓이기 때문에 이 법률 위반 행위가 장기간 다수의 근로자에게 영향을 미친 경우 페널티가 기하급수적으로 늘어날 수 있음을 유의할 필요가 있습니다. 이 외에도 하나의 청구만 승소하면 변호사 비용 전부가 보전된다는 점도 중요한 포인트입니다.
Okay, so we have talked about the basics of what a PAGA action is. We've also mentioned that PAGA actions are very different from other types of lawsuits, right? What makes them so different? There's a few things. Number one, the named plaintiff, the person who files the PAGA lawsuit, is not required to obtain court permission to represent the PAGA members. They don't need to ask for anybody's permission. They simply get to file the lawsuit on behalf of whatever group they choose. And generally speaking, they're allowed to proceed. There is no process like there is in a class action, which is different, where they have to seek court permission to represent the group. So if I go in to court and I say, I want to represent all of your non-exempt employees, then I get to represent all of your non-exempt employees. Additionally, the named plaintiff in a PAGA lawsuit is legally entitled to obtain the names and private contact information for all of the PAGA members, all of the people they are trying to represent at the start of the lawsuit. They will go through a process called discovery, where they send you a request, and under California law, you have to provide it. That is one of the things that makes these so dangerous, because assuming you do not try to negotiate with the plaintiff, they can immediately get all of the information for your past and current employees, all of the people they're trying to represent, and their lawyer will start calling those people one by one to try to get them to join the lawsuit. They will promise them money. It will be very disruptive and damaging to your business. They can say bad things about the business. It's not good. It is really a form of legalized harassment, but they are permitted to do that in a PAGA lawsuit. Additionally, what makes PAGA lawsuits different? Representative PAGA claims, meaning the claims that the employees are asserting on behalf of a large group, cannot be compelled to arbitration, right? Other types of claims in California, individual claims, class action claims, can be compelled to arbitration. But remember, this is the sue your boss law. The legislature wrote it so that it is almost impossible to defend. And one of the things they put in the law is that the representative PAGA claims cannot be forced into arbitration, meaning they get to proceed in court on a group basis and seek group damages. That's very dangerous. PAGA claims also cannot be settled, released, or dismissed without the approval of the state of California and the court once they have been filed. Meaning you cannot simply approach someone and have them sign a release agreement and have the lawsuit go away. That is not legally permitted. That release will not be valid, right? You have to have any settlement, dismissal, or release approved by the state of California, and if a claim has been filed, also with the court. And it is a long process to get that approval. So they are not easy to get rid of. However, the one drawback to employees for PAGA claims, they have all these advantages. What is the one small drawback? If they win, they have to give 65% of the monies they recover in a settlement or a judgment to the state. That doesn't help you as the employer because you still have to pay the money, but it limits their recovery. They don't get to keep all of it. And I will tell you later why, despite that fact, so many lawsuits, PAGA lawsuits, keep getting filed. But just briefly, I'm sure some of you are asking, okay, we know about PAGA lawsuits. What specifically are the differences between PAGA lawsuits and class action lawsuits? Right, we discussed those are different types of claims. Well, there's a few differences. These are just a few of them. Number one, in a class action lawsuit, the class period start date is 4 years before the complaint is filed. Right? A PAGA lawsuit only goes back 1 year. So class actions are much, much bigger. Additionally, in a class action lawsuit, employees keep 100% of any settlement or judgment, not just a small fraction. But the big drawback is the named plaintiff in a class action lawsuit does eventually have to obtain court permission to represent all of the class members. And because of that factor, because that can create some risk, sometimes people will prefer to file a PAGA lawsuit instead of a class action lawsuit. But remember, a single complaint can contain both class action claims and PAGA claims. And different rules are going to apply to both of those claims.
파가 클레임에 대해서 추가적으로 중요한 사항을 몇 가지 정리해 보자면, 우선 일반 집단 소송은 소재계약이 전에 집단 소송으로서 이제 청구 요건을 갖추었는지 법원의 판단이 필요한데, 파가 소송은 이러한 승인이 필요하지 않습니다. 다음으로는 보통 회사들이 여러 가지 클레임을 대비해서 직원 입사 시에 아까 말씀드린 중재 합의를 많이 해두시는데, 파가 클레임의 경우 대표 소송으로 진행되는 클레임은 중재로 진행하기로 하는 이제 사전 합의가 인정되지 않습니다. 그리고 파가 소송이 제기되면 캘리포니아 주 또는 법원의 승인 없이 근로자와의 사이에 사적으로 합의, 세틀할 수도 없습니다. 마지막으로 일반 집단 소송과 파가 클레임은 늘 동시에 제기될 수 있다는 점을 유의하실 필요가 있습니다.
Okay, so just to give you an example of what we just went over, this is a sample timeline for a class or PAGA lawsuit. Right? We discussed that they cover claims that span a long period of time. In the case of a PAGA lawsuit, the PAGA period starts 1 year before the notice. In the case of the class action lawsuit, it starts 4 years before the complaint, and they continue to grow into the future, right? So let's say long time period where the plaintiff is saying violations occurred over this period of multiple years. And so you can see here, depending on what kind of claims are filed, if it's a class action, it starts way back here, 4 years ago, right? You may not even have records going back that far. That's how far back it goes. If it's a PAGA lawsuit, however, it's only going to start here, which is only a year and 65 days before the complaint, 1 year before the PAGA notice. And importantly, as we discussed, the lawsuit continues to grow in size as long as it is out there. It keeps going every single day. So it could take 3 or more years to get to trial. And if it does, you can see that the total lawsuit covers 7 years worth of pay periods and employees, a long time frame. And that makes it very dangerous to employers because that is a lot of damages that the plaintiff can try to collect. So it's a very long time frame you have to keep in mind. So what are some common questions that we get about class and PAGA lawsuits? People ask, if I violate the labor code, but it was unintentional, I do it accidentally, can an employee still file PAGA claims against me? The answer is yes. PAGA does not care whether the mistake was made in good faith. It is a strict liability statute. If you make an error, even the tiniest error, 1 day late, 1 minute short, $1 short, that is a violation. And good faith or other reasons do not excuse it. So yes, they can still file a PAGA claim against you. Another question is, if I violate the labor code, but I correct my mistake, can an employee still file PAGA claims against me? The answer is yes. If you did not provide $1 of pay if you were short, but you pay it later, it still was not timely provided. Even though the total amount was paid, it wasn't paid on time. And the pay statement, the pay stub, could still be wrong. So if you correct your mistake, yes, you can still get sued. Correcting the mistake does not take away an employee's ability to file a PAGA claim. Now, I will qualify that and say, yes, there is some language in PAGA that authorizes employers to go through a cure process to protect themselves under very limited circumstances. But it is so expensive and so risky to do so that it is not anything we would ever advise. It involves you having to pay interest and damages and attorney's fees. And then if the employee disagrees that the violation has been cured, they can still sue. So yes, there is technically some cure language in PAGA, but practically speaking, it does not help employers in most cases. Another question, can I have employees sign an agreement in which they waive their right to file PAGA claims against me in the future? Can I just have them sign a waiver? Can I pay them to waive their right to file PAGA claims? No, that is illegal under the law. You cannot get around PAGA claims by paying an employee to waive their right to sue you. Does an employee need to prove to the court that his claims have merit, that they are true or accurate before filing a PAGA lawsuit? No. Employees can file false claims. They can file claims that are mistaken. They are still allowed to file them. They are still allowed to get a trial on them. And even if you were to win a trial, again, you would have to win 100% to defend yourself, right? One violation equals a loss. But even if you win 100%, you don't get to recover anything from the employee, and there is no penalty to them for filing it. That is one of the reasons there are so many lawsuits. There is no penalty for an employee to file false or mistaken claims. They can simply file them, and you have to defend against them. Another question, does an employee need the permission of any other employees to file PAGA claims on their behalf? No. If I wanted to file PAGA claims on behalf of everybody who works at Lewis Brisbois, in the state of California, I don't need the permission of anybody. I am simply allowed to do that without telling them, without their permission. I can just go into court and file a complaint and try to collect damages on their behalf, even if they disagree. Even if they think they've been paid properly, I can still go into court and file claims. Another question, once an employee files a PAGA action against me, can I offer to pay him money to simply dismiss the lawsuit? Can I go to the person who filed the lawsuit and offer to pay them to go away? The answer is no, you cannot do that. Again, dismissals cannot happen without the approval of the court, state of California. And once it is filed, it is too late. Now, there are some extenuating circumstances where a court might approve such a dismissal, but those are very rare. Usually it has to do with financial hardship or a company going out of business, but courts are specifically prohibited from allowing a dismissal where the named plaintiff has been paid off. They do not want to reward somebody at the expense of all the other employees that the claims are filed on behalf of. So generally speaking, no, once it is filed, you cannot pay off the plaintiff. And in many cases, the court will allow the lawsuit to go on even if the named plaintiff withdraws. So once it is filed, it is generally too late. Another question, once an employee files a PAGA action against me, is there any way to stop my potential liability from continuing to increase? Can I stop the PAGA period from going up? Again, the answer is no. The PAGA period continues to grow as long as the lawsuit is out there. Now, you can take steps to try to stop violating the law if you think you're doing something wrong. But that does not stop the employee from claiming that violations have occurred. There is nothing you can do to just give yourself automatic protection. So even if you try to make fixes going forward, as long as pay periods continue to go up, as long as the number of employees continues to grow, the plaintiff can still claim extra damages.
자주 들어오는 질의에 대해서 간단히 설명해 드렸는데요. 몇 가지만 강조를 해드리자면 고용주의 법률 위반이 고의가 아니었거나 또는 사후에 시정을 했더라도 파가 클레임 대상이 될 수 있다는 점. 그리고 근로자와 사전에 대표 소송으로 진행되는 파가 소송을 제기하지 않는 걸로 보통 소송 포기 합의 이런 거라고 하는 이런 합의를 할 수 없다는 점. 그리고 일단 파가 소송이 제기되면 아까 말씀드린 대로 사적으로 세트, 합의할 수 없다는 점, 이런 점들이 중요한 점이시겠습니다. 그리고 마지막 포인트와 관련해서는 파가 소송이 정식으로 제기되기 전에는 합의를 시도해 볼 수 있다는 점도 기억하실 필요가 있습니다.
Okay, so you now know a little bit about how PAGA claims work. Why should you care as an employer in California? Well, number one, because PAGA claims often present the highest risk to you of any type of claim that can be filed against you. The requirements of PAGA are very technical. 1 minute late, 1 minute short, 1 penny short can be a violation. The violations are also easily measurable, right? It's data, it's time entries, it's pay. It is not like other types of claims where there can be disputes about fact. PAGA is very data driven. Additionally, one violation can trigger multiple other violations. We briefly touched upon this earlier. So if you fail to pay an employee $1 for something, then not only did you fail to pay minimum wage, you may have also failed to pay enough overtime wages. You may not have given the employee an accurate pay stub, right? If it does not contain that extra dollar. You may have also failed to pay the employee timely because if you correct it, it's late. And then if the employee leaves, resigns, or is terminated, and the employee is still owed $1 because you didn't know about the error, that is a failure to pay wages at separation. So that one tiny error can trigger 4, 5, or 6 other violations, which can increase the damages. What's also hard is that the requirements of the law change frequently. Definitely every year, sometimes multiple times per year. The requirements are always changing. It is hard even for lawyers like us to keep up. And so it is very easy to commit a violation because the law has changed and you didn't know about it. Also importantly, PAGA claims are not typically covered by EPLI insurance, or you have to pay a ton of money to get coverage and you get very little coverage, maybe as little as $50,000 or $100,000 of defense-only costs, meaning your carrier will pay for the first few months of your defense, but will not pay for any settlements, will not pay for any judgments, and will not pay for you to go to trial. If it costs $500,000 to go to trial and you have $75,000 in coverage, it's not going to get you very far. Now, why do carriers not provide more coverage? For all of these reasons, because they know PAGA cases are nearly impossible to win. The law was written that way. It is essentially a form of legalized extortion that the legislature passed. And it is so impossible to win that even insurance carriers will not give you coverage for it, or not very much. Finally, the most important reason, because of the automatic attorney's fees requirement. Plaintiffs' attorneys know that they can file a PAGA lawsuit, and if they win on anything, they will get all of their attorney's fees. They do not care about the employees. In PAGA lawsuits, whether they're settled or go to trial, the employees themselves generally get very little. Remember, most of the money goes to the state. The attorneys do not care. The attorneys do not have to share money with anybody. If the PAGA members get $100 for one violation, the attorney still gets $500,000. They get all of their fees. That is why so many of these PAGA lawsuits are being filed, and why PAGA lawsuits are now being filed more than any other kind of lawsuit, because they are extremely profitable for plaintiffs' attorneys. Plaintiffs' attorneys cannot even keep up. They have so many people lining up to get these lawsuits filed that they have to work with other smaller firms just to file them all. It is really out of control. You have defense attorneys switching to the plaintiff side because it is so much more profitable to be a plaintiff's attorneys, because these PAGA lawsuits are so easy to file, win, and get settlements on. That is the number one reason why these lawsuits are being filed, and why that is never going to change as long as that attorney's fees requirement is in place. And so here you can see claims are being filed at record rates, right? In the last 1 year alone, the PAGA notices, threatened lawsuits have gone up by 34%. The last year, they are being threatened all the time, thousands of times per year. A single law firm may file 1,000 or 3,000 PAGA notices every year. PAGA lawsuits have similarly increased by 100% in the last 5 years. Everybody is getting sued. It is not just, one particular group, one particular industry. It is a cost of doing business in California. So what can you do to avoid a PAGA lawsuit? Fortunately, there's not a lot because of the way the law was written. Now, you can do things like try to avoid labor code violations by making sure that your policies and procedures are up to date. Remember, they change all the time. You can also have employees sign California law compliant arbitration agreements that require the arbitration of their individual PAGA claims and the stay or the pause of the representative PAGA claims while their individual claims are being arbitrated. Again, you cannot force them to arbitrate representative PAGA claims. This is just kind of a temporary roadblock that you could throw up to make it harder for them to proceed with any representative claims. But remember, the agreement has to be California law compliant. There are very specific requirements that only California has for employee arbitration agreements. You have to have the current language. Language from other types of agreements will not work. You can also take all reasonable steps to cure any violations that you noticed. This includes conducting payroll audits, conducting training, disciplining employees who do not comply, right? Again, even if you commit a violation and correct it, you can still get sued, but this may help to limit your damages. And then finally, you can monitor the LWDA's website. There's actually a website where you can see if a PAGA notice has been filed. But the most important thing, if you learn nothing else from today's presentation, if you get a PAGA notice or if you get a PAGA complaint, you need to take action immediately. Right? If you get the notice, but a complaint has not been filed yet, there is a possibility that you can settle it without court approval. Right? Once the action gets filed, that is not an option. So if you get a notice, act immediately. And it's important that you consult with an attorney immediately, and not just any attorney, right? We've gone over all the reasons why PAGA is so different from every other law. It is critical that you consult with a PAGA specialist. That can be someone like myself or someone else, but it needs to be a specialist. Consulting with just a regular attorney or even employment attorney, if they do not specialize in PAGA matters, you are likely going to get some bad advice, and you can make your situation a lot worse. So if you do nothing else, if you get a PAGA notice or a PAGA complaint, consult with a PAGA specialist immediately, and they can, give you advice and hopefully help you get rid of it as quickly as possible.
마지막으로 저희 파가 클레임을 예방하기 위한 여러 방법을 소개해 드렸는데요. 그중에 다시 한번 설명드릴 것은 아까 대표 소송으로 진행되는 파가 클레임에 관한 중재 합의는 인정되지 않는다고 설명드렸는데요. 대신 개인 소송으로 진행되는 파가 클레임은 사전에 중재 합의가 가능합니다. 나아가서 본인 스스로를 위한 이 파가 클레임을 중재를 통해서 진행하는 와중에 이제 그 중재가 진행되는 동안에는 동시에 제기된 대표 소송은 홀드하도록 사전에 합의하는 것도 가능하다는 점 유의해 주시면 되겠습니다. 그리고 사소한 노동법 위반도 파가 클레임의 근거가 될 수 있고 하나의 위법 행위가 여러 노동법 규정 위반에 해당할 수 있다는 점도 유의하셔야 하고요. 마지막으로 그 LWD에 아까 그 말씀드린 에이전시 홈페이지에서 파가 노티스가 있었는지 확인할 수 있습니다. 말씀드린 대로 정식 소송으로 진행되기 전까지는 이제 사적으로 세틀 합의가 가능하니까 혹시 문제가 제기될 우려가 있다면 노티스가 있는지 모니터링 하시고 그리고 바로 변호사에게, 특히 파가 클레임을 전담하는 이런 전문 변호사에게 연락을 취해서 빠르게 문제가 해결될 수 있도록 해주시면 저희도 감사할 것 같습니다. 저희 설명은 여기까지입니다.
Well, hope that information has been helpful for all of you. Again, this is something that is not going away, unfortunately, in California. But if you get good legal advice, this is something that is manageable and tolerable. And so, again, I hope this has been of some benefit. If you have any further questions about PAGA, you can feel free to reach out to me directly at my email address or phone number here, and I'll be happy to answer them going forward. And with that, I will turn over the presentation to my colleague Celine Sim of our offices, who is going to speak to you briefly about sexual harassment.
안녕하세요. 저는 셀린입니다. 저는 오늘 직장 내 성희롱 클레임이 발생했을 때 어떻게 대처해야 하는지, 그리고 이런 클레임을 어떻게 예방할 수 있는지에 대해서 간단히 속성으로 안내해드리는 시간을 갖도록 하겠습니다. 캘리포니아에서 사업을 운영하는 고용주 중에 직원이 5명 이상이신 분들은 성희롱 및 학대 행위 예방에 관한 교육을 직원에게 제공해야 합니다. 이 교육은 의무고요. 주제인 학대 행위와 성희롱 예방, 또 차별 금지, 보복 금지, 성 정체성에 대한 표현에 대한 내용이 교육에 포함되어야 됩니다. 오늘 저희는 이 주제 중에 직장 내 성희롱에 대해서, 성희롱 클레임에 대해서 알아볼 거고요. 성희롱은 성차별의 한 형태이고요. 미국 민권법 제7조와 캘리포니아의 공정고용 및 주거법 KITA-라고 부르는 법의 위반 행위입니다. 두 가지 법 중에 어떤 법이 적용이 될까 궁금하실 수 있는데요. 가장 더 엄격한 법이 적용된다고 생각하시면 됩니다. 그리고 보통은 캘리포니아가 더 엄격한 법을 가지고 있기 때문에 캘리포니아 법에 삐아가 적용되는 경우가 많다고 생각을 하시면 될 것 같습니다. 요즘 많은 분들이 몇 년 전에 미투 운동도 있었고요. 그래서 상황이 좀 정리되었을 거라는 기대와, 그리고 사람들의 인식도 제고되기도 해서 직장 내 성희롱 클레임이 아직도 그렇게 심각하고 문제가 많은가 하고 물음표가 있을 수 있어요. 저도 한번 확인을 해보니까 궁금해서 지난 4, 5년간 매년 평균 288건 정도의 성희롱 사건이 캘리포니아에서만 접수됐다고 합니다. 그리고 주목하셔야 될 부분은 그중에 80%가 관리자나 고용주의 개인 이름이 직접 언급됐다는 것입니다. 약간 심각성이 느껴지실 거라고 생각이 듭니다. 어떤 종류의 직장 내 성희롱이 있을지 궁금하실 것 같은데요. 두 가지 유형이 있습니다. 대가성 성희롱과 그리고 적대적인 근무 환경입니다. 대가성 성희롱은 이름과 같이 직장에서 고용이나 직무에 관련된 대가로 성적 요청이나 원치 않는 행동에 비용을 요구했을 때 요구하는 경우입니다. 예를 들어 관리자가 승진이나 고용을 성적인 요구와 연계시키는 상황이 되겠고요. 비교적 드물게 발생하지만 피해자의 고용 조건에 직접적인 큰 영향을 미치기 때문에 그 심각성은 매우 크다고 할 수 있습니다. 그 다음으로 더 흔히 발생하는 적대적 근무 환경. 이는 이제 특정 보호신분, 예를 들어서 성별, 성정체성, 인종 또는 나이에 기반한 괴롭힘이 심각하고 지속적이며 그로 인해서 직원이 불쾌하고 적대적인 환경에서만 일하고 있다라고 느낄 때 발생합니다. 이 정도의 기준에 대해서 궁금하실 것 같아요. 어느 정도가 불쾌한지, 어떤 사람은 쉽게 불쾌함을 느낄 수도 있고 어떤 사람은 그렇지 않을 수도 있으니까요. 근데 법적으로는 그래서 두 가지 기준이 모두 충족되어야지 근무 환경이 성립되는데요. 그 두 가지 기준은 객관적인 기준과 주관적인 기준입니다. 객관적인 기준은 합리적인 사람이 그 직원의 상황에 처했을 때 그 환경을 적대적이나 모욕적으로 느낄 것이다. 그리고 주관적인 기준은 해당 직원이 실제로 그 환경을 적대적이라고 느꼈는가, 두 가지가 모두 충족되어야지 근무 환경이 성립이 됩니다. 그러면 이제 우리가 이 주제가 우리한테 왜 중요한지에 대해서 알아보겠습니다. 직장에서 성희롱이 발생하는 경우에는 관리자의 개인 책임과 고용주의 법적 책임 두 가지가 다 있습니다. FIA에 따르면 성희롱이 발생한 경우에 고용주는 엄격한 책임, strict liability라고 하는데요. strict liability를 지게 됩니다. 이건 법적 용어인데 이게 어떤 뜻이냐면은 관리자가 직원에게 성희롱을 저지른 경우 고용주는 이를 방지하기 위한 조치를 취했는지 여부하고 상관이 없이 발생했다는 그 사실만으로 자동으로 책임을 져야 한다는 뜻입니다. 캘리포니아에서는 이러한 성희롱 사건에 대해서 중재 해결을 강요할 수 없습니다. 이걸 법에서 금지하고 있고요. 이 뜻은 arbitration agreement, 중재 합의서에 성희롱 사건을 중재로 수행한다 명시가 되어 있어도 집행이 불가능하다는 뜻입니다. 따라서 이러한 경우 재판으로 가게 되는데요. 배심원 재판이 되겠죠. 이런 경우에는 몇백만 달러에 달하는 배심원 판결이 나올 수 있습니다. 네, 요즘 배심원 판결 트렌드가 어떤지 걱정을 많이 하시는 분한테 여쭤봤는데요. 예전에는 피해 직원이 정신적 고통에 따른 손해배상을 청구할 경우에 그 손해를 증명을 하기 위해서 직원이 어떤 치료를 받았는지, 얼마나 심각한 치료를 받았는지, 오래 받았는지, 어떤 약을 처방받았는지 이런 거를 하기도 했었는데 그게 보통이었던 것 같아요. 근데 최근 배심원 판결 트렌드는 피해 직원 주위 사람들의 얘기를 더 많이 듣는다고 합니다. 이 뜻은 가족이나 친구나 그 직원의 동료 등의 증언에 무게를 더 준다는 뜻이고요. 다른 얘기로는 고용주에겐 더 어려운 싸움이 될 거라는 의미가 되겠습니다. 그리고 이러한 사건은 공개될 수 있습니다. 합의를 하더라도 사건 발생 사실에 대해서 비밀을 지키는 약속을 하는 것은 법적으로 금지되어 있습니다. 약속을 하더라도 그거를 집행을 할 수가 없습니다. 이를 통해서 발생하는 부정적인 언론 노출과 평판 손상은 기업이나 개인에게 모두 큰 부담이 될 거라고 생각이 됩니다. 자, 그러면 직원이 성희롱 클레임을 어떻게 제기하는지 간단히 알아보겠습니다. 피해 직원이 성희롱 클레임을 제기하려면 바로 소장을 법원에 제출하는 게 아니고요. Civil Rights Department라는 곳에 클레임을 해서 소송 권리 부여 서한 Right to Sue Letter라고 하는데 이 레터를 받아야 됩니다. 이 레터를 받은 후 3년 이내에 정식적으로 소송을 할 수 있습니다. 기존 1년보다 시효가 길어졌기 때문에 회사에서 이런 클레임이 내부 클레임이나 아니면 낌새 해프닝이 있는 것만으로도 주의를 해야겠다라는 걸 좀 느끼시고 대처를 해야 됩니다. 그래서 관련된 모든 기록을 다 잘 보관해 주셨으면 좋겠어요. 왜냐하면 3년 동안은 직원이 증인이 될 수 있었던 직원이 퇴사를 할 수도 있고요. 또 기록도 없어질 수도 있고요. 잘 보관이 안 될 수도 있고요. 그리고 직원이 있다 해도 기업이 왜곡될 수 있는 충분한 시간이라고 생각됩니다. 다큐멘테이션이 가장 중요합니다. 그러면 이제 직원이 소송을 제기를 했거나 아니면 하겠다고 위협을 할 때 어떻게 대처해야 될까요? 직원이 직장 내 성희롱 문제나 차별 문제로 소송 제기할 경우에는 당연히 첫 번째로 해야 될 일은 즉시 노동법 변호사에게 연락을 하는 것입니다. 그리고 먼저 액션을 취하시기 전에 저희랑 먼저 상의를 하시고 취하시는 거를 굉장히 강력히 권고드리고요. 그리고 고용관행 책임보험이라고 하죠. EPLI 가지고 계시면 보험사에 바로 텐더하셔야 됩니다. 그리고 다음으로는 사건에 대한 조사를 해야 됩니다. 저희는 내부인보다는 외부 변호사와 함께 인베스티게이션 하실 거를 추천을 드립니다. 가장 큰 이유는 전문적인 전문적인 부분도 있겠지만 그보다 더 중요한 이유는 어터니 클라이언트 프리빌리지라는 게 있어요. 어터니 클라이언트 프리빌리지는 변호사 고객 사이의 비밀 유지 특권이고요. 그렇기 때문에 이 성희롱 클레임 사건에 대해서 기밀성이 유지될 수 있습니다. 그리고 모든 비디오, 문자 메시지, 이미지, 사진, 통화 기록 등 관련 증거는 철저히 다 보관하셔야 되고요. 말씀드렸다시피 소송 시효가 조금 더 길어졌기 때문에 증거가 인멸되지 않게 관리 수치를 취하셔야 됩니다. 그리고 한 가지 더 강조드리고 싶은 거는요. 해당 직원에 대한 보복 행위를 주의를 하셔야 돼요. 물론 막 대놓고 보복 행위를 하시지는 않을 거라고 생각이 듭니다. 근데 이제 보복 행위가 단순히 너무 이제 겉으로 어비스하게 드러나는 해고나 선택적인 징계나 뭐 불리한 업무 배치나 승진 누락 같은 그런 보복 행위뿐만이 아니라 직원을 따돌리거나 없는 사람 취급하거나 알게 모르게 무시하는 그런 분위기 이런 행위도 다 보복행위로 감추될 수 있습니다. 보복행위가 무서운 이유는 또 보복행위로 하나의 클레임으로 소송을 할 수 있기 때문입니다. 잘 기억해 두시면 좋을 것 같습니다. 그러면 한 가지 제가 다시 한 가지만 더 말씀드릴게요. 불만 시 어떻게 대응할 것이냐. 이번이 공식적이든 비공식적인 방법이든 문제를 제기했다면 성희롱 클레임에 관련된 컴플레인을 했다면 공주는 반드시 이를 조사하셔야 됩니다. 직원이 이럴 수 있어요. 큰 노이즈를 만들고 싶지 않다. 직원들하고 사이가 나빠지는 게 싫다. 조사 안 했으면 좋겠다. 그래서 여기에 따라가시면 안 됩니다. 고용주의 조사 대응은 고용주 선택이 아닙니다. 법적인 의무입니다. 때문에 직원이 어떤 의견을 내든 클레임을 받으시면 반드시 조사에 들어가셔야 됩니다. 그리고 만약에 공식적으로 클레임이 들어오는 그런 일이 없다 하더라도 직장 내에서 성희롱이 목격됐다는 사실을 만약에 들으시면 고용주는 그에 대해서 조사를 하셔야 됩니다. 그러면 예방 방법에 대해서 말씀을 드리고 마치도록 하겠습니다. 첫 번째 단계는 명확하고 포괄적인 정책을 만드시는 겁니다. 성희롱이 무엇인지, 직장 내 성희롱이 무엇인지, 그리고 그 결과가 어떻게 되는지를 명확히 이해할 수 있도록 명확한 포괄적인 정책을 확인을 하시고 그 핸드북 한번 리뷰해 보시기를 권해드리고요. 그리고 무관용 정책, Zero Tolerance Policy라고 하는데요. 이런 폴리시를 가지고 계시면 성희롱이 법적 기준에 미치지 않더라도 즉시 대응할 것을 회사가 약속함으로써 그리고 이걸 전달하고 정기적으로 교육함으로써 직원들이 이런 성희롱에 대한 중대함, 중요성을 알 수 있고 그리고 만약에 발생하더라도 어떻게 해야 되는지 교육이 될 수 있기 때문에 그 부분을 한번 폴리시를 점검해 보시기를 권해드리고요. 그리고 아까 말씀드렸다시피 법적으로 요구되는 의무교육이나 훈련 반드시 실시하셔야 되고요. 실시하시면 나중에 이제 맨 마지막에 서티피케이트 나와요. 그거 다 보관하셔야 됩니다. 그리고 보고 절차를 성희롱 신고 절차를 한라인이나 오픈도어 정책 같은 걸 도입하셔서 다양한 경로를 열어두시는 것이 좋아요. 그래서 직원들이 언제든 말할 수 있게 작은 일이라도 언제든 보고가 될 수 있게 회사는 알고 있어야 되기 때문입니다. 그리고 성희롱 피해자에게 지원을 제공하는 것도 중요하고요. 더 제일 중요한 거는 리더십 운영진과 관리자분들의 노력입니다. 그래서 존중과 무관용 문화를 지속적으로 육성하실 수 있도록 노력하는 것이 중요합니다. 그러면 오늘 발표는 제 세미나는 이 정도로 마치고요. 해주셔서 감사합니다.